Hey, what's going on, everybody? And this is Rose, host of Show. And guess what? We're a little late. I get it. You guys are always accustomed to us being here every Saturday at 10 p.m. Pacific time. So we had to rush this in at the last minute, had some technical difficulties. So I am glad for those coming back to listen, who's listening on your platform or watching us live on your favorite social media site. So this is Rose. I'm your host and the founder of McDonald Bookkeeping Services, where I provide accounting services for small business owners. And I'm usually here with my co-host, but she is traveling today. She is, I believe, on her way to Italy. So it is going to be me again today. We have a really great guest, the first actual attorney that we've had on the show. So I'm very pleased to have, someone with a lot of great knowledge to helping our small business owners. And actually, it's something that myself, even my co-host, had looked into about trademarks. Your brand is important. Copyright and your content is important. So this is going to be so extremely useful to you business owners that maybe think it's not needed or not really knowing the relevance of it or the importance of it. So my guest today is Devon Miller of IP Law. I'm going to kind of let him give you the some story about himself, his background. I'm going to bring him up on the screen shortly, and then we are going to get started with the questions and learn everything we need to know about copyright, patent, and how to get a hold of him if you have some questions. So let's on the screen right now, get the show started. How are you?
I'm doing pretty well. Life is good, so no complaints.
Thank you so much for allowing us the opportunity, or for me today, the opportunity to come on the show. We've never actually had anybody of your caliber, so it was really a great advantage for us to have you on the show because I think that you could bring a lot of insight and education to our listeners, because a lot of people just run a business, they have a product or they have a brand and they don't think of ownership of it. So if you can kind of maybe tell our listeners a little bit about yourself, like your background, how you actually got involved and why you chose this field of choice specifically.
Yeah, so that's probably a shorter answer to it, and then I'll give a shorter question to a longer answer. But so I started going way back for a little while. So I did I did a couple degrees in electrical engineering as well as Mandarin Chinese. And kind of as I got to the end of that, I was looking to see what I wanted to do was when I grew up, or how I wanted to incorporate that into career. And I didn't necessarily quite want to be an engineer. I liked working on a lot of electrical stuff and on those type of projects, but I wanted to do something a bit different. I didn't want to be stuck on a project. So I really kind of was at a crossroads of and I had kind of two interests. One was that I wanted to be an entrepreneur and work or do startup and small businesses myself. And then I also liked the legal and law aspect. So I graduated, went off to graduate school. I ended up doing both. So I did both a law degree as well as an MBA. So I did those contemporaneous, graduated, long story short. I've been worked for some larger law firms before kind of deciding I would like to do focus my practice, what I do with life, on helping startups and small businesses. So I founded Miller IP Law a couple years ago with the idea of helping startups and small businesses. A lot of times they're overlooked in the marketplace, and I wanted to kind of really set it up to focus to help those that are the smaller and the up and coming businesses to make sure that they have the protection they need, whether it's patents, trademarks, or copyrights.
So what led you to that field, though? As a young boy, is it something that has just always interested you? But why this field of law, specific field?
It was a way that I could continue to. So I went into electrical engineering. I like projects. I like electronics. I like software. I like those, kind of the techie or nerdy type stuff. But as I got to the end, I didn't necessarily want to do it. So I had an uncle that was also a patent attorney. So kind of as I was trying to decide what I wanted to do after I graduate, whether it's go be an engineer and I want to do that for my career, or how I wanted to adjust that, kind of with conversations, knew what he had done, discussed it with him a little bit and decided it sounded like kind of a good mix to where I could still work with a lot of startups, small businesses, hear and see a lot of cool inventions, a lot of projects, and get to have a lot of variety. So that kind of started me down that path.
What kind of businesses do you actually work with that you think need to, that may not be informed enough, and then maybe explain the differences between trademark, copyright, that people may not understand, how it could be relevant to their business?
Yeah, and I'll probably flip that question because I think it'll answer it a bit better. So, typically patents are going to go towards invention. So if it's a product, whether that's software, hardware, mechanical stuff, electrical stuff, so we
Right.
work with it. That's what your patents are. Trademarks, as you mentioned, are kind of all towards brands. So if you think of a logo, a catchphrase, a product name, a company name, those are kind of the brands. And then copyrights are going to be more on the creative. So whether it's a book, a movie, a photo, podcast, or anything of those, that's going to be your creative works. And really, what kind of businesses need it? It kind of depends on what kind of business you are. If you're nothing against them by any means, a mom and pop shop, you just want to be a local or serve a local community, a local audience, you want to serve the neighborhood, you're probably not going to need to protect it as much. Where you're really going to look at it is, hey, are we building something that's going to become a bigger company? So are we building something that we want to have a brand that has recognized outside of our just local area, whether it's statewide, nationwide, or something? Or are you building a product or an invention that you're going to want to be able to sell across a larger audience? Those type of things. And you're saying, where is our value? And then how do we protect that? So that's kind of where you start as businesses, as a startup or small business, saying, what kind of business do we want to be? And then where's the value of our business? And do we want to protect that value?
Is there a certain timeline that people should look at when they're looking of, let's just say first for a product, or an invention? Because, you see a lot of things on TV now. There's Shark Tank and all this other stuff.
Sure.
So how do you know at what stage you're at when you might say, okay, I need a patent?
Yeah, so couple thoughts on that. The earliest stage is you at least have to have it far enough along is what you can do. It's called conceptual reduction of practice, which basically means you can explain your product to a level that somebody else in your industry would be able to understand it and replicate it. So if you
Mhm.
haven't, if it's still in the idea stage, if you haven't thought it to, if you can't explain it to that level, you're probably not ready yet. And then beyond that, as far as you're saying, so that's kind of your minimum bar. And then when you move beyond that, it's kind of depends on what your risk tolerance is. So I'll give you a couple examples. Let's say you're going to do an R&D project that's going to take 2 or 3 years. You're going to be fairly tight-lit. Most of it's going to be in-house or internal. Then you're saying we can probably wait for a period of time until you're ready to put it out in the marketplace. On the other hand, let's say you're introducing it to the marketplace, you're doing promotion, you're doing conferences, you're putting it out there such that you have a much higher level of exposure, a lot more people are going to see it, then you may say we probably need to move that timeline up. So it kind of depends how quickly you're going to put that in the marketplace. The other thing you may want to look at is kind of how crowded the marketplace is. If it's something there's a lot of people innovating, all trying to do the same or similar thing, all trying to save or solve a solution, solve the problem, find a solution, then you may say, okay, it's getting crowded. We have what we think is a solution. We'll want to protect that. On the other hand, if you're saying, hey, this isn't a crowded marketplace, there aren't a lot of competitors, or what we're doing is significantly different, then you may be able to hold off a bit.
So I don't know the whole background of this, but I hear that after you get something trademarked, I don't know if that's the same, if it's the same when it comes to whether it's trademark, patent, copyright, that you should hire someone or to research to make sure no one's utilizing.
Mm-hmm.
And so, what does that look like? I mean, is that necessary? How important does that play a role when you have to have something trademarked and patent?
It's not required. It's not necessary. It's good. So I'll put it that way. So if you're to look at really, you know, there are legal requirements as far as to get a patent or trademark. They don't require you from the patent and trademark office to have done a search. So when you submit, whether it's a patent or trademark, they will go out and do their own internal search. They'll do an examination of whether it's going to be patentable or trademarkable. So in that sense, you could just submit a patent or trademark. They'll do an examination, and then you'll come back and either give the results, and then you have an opportunity to argue back and forth as to whether or not you believe they're right. A lot of times, when that way you're referring to as a patent or a trademark search, kind of it's a step before you actually file your patent application or trademark application. And a lot of the reason you'll do that is because, or you'll do those searches is so you can get an idea of whether or not it makes sense to do a larger investment, time, effort, money in doing a patent or a trademark. You're saying, does it look like there's a likelihood that we're going to be able to get a patent or going to be able to get a trademark, or just not even likely to make it through such that it wouldn't make sense to go and apply for a patent or trademark? So that's a lot of times it's not required, but a lot of times people are saying, before I make the larger investment of time and money, I'd like to at least get an idea of the landscape.
So you said if it's trademarkable.
Mm-hmm.
So what does that mean? I mean, it sounds to me like then something they may not be. What is it's saying? Like, I don't know that definition, trademarkable.
So there's a couple different things. Trademarkable, whether or not so it means, whether or not it's something that can be trademarked, and there's kind of really a couple different standards. So
Okay.
One standard that's across the board is whether or not it's a term that is just simply merely descriptive, meaning you can't go get a trademark on the word apple if you're selling the fruit apple, because everybody uses that word to describe an apple, right? The fruit apple. And so you can't go get something. If that's how everybody uses that word to describe it, it's simply just not a word that you can trademark. The other thing that kind of comes into that is if there's so lots of products, lots of companies out there, lots of people who are doing things. You wouldn't be able, let's say you wanted to go start a phone company, you wanted to sell smartphones. You can't go call your company Apple because Apple already exists out there. So really the other standard on trademarkability is whether or not what your mark is or what your trademark would be confusingly similar to what somebody else is already doing or already trademarked. So that way, if customers would be confused, are you selling the product? Is your competitor selling the product? They don't know who's selling the product or where it's coming from or which company, then you're not able to trademark it. So those are kind of your two primary standards. One, is it going to be confusing with whether other trademarks are already out there? And then is it just merely descriptive of a word that everybody uses?
Now, what if a brand? I'm sure many business owners have looked at this. I have myself. My clothes, I believe, her logo.
Mm-hmm.
She had to research or trademark her logo. So how important is that, and how is that process? So, for example, my last name is McDonald, and it's a very common name, obviously. And McDonald, and I'm using McDonald services. And so for people who have Smith and Jones and that type of thing, how does that benefit us as a business, their logo or that name? Or is it just, can you trademark the logo, but then the name is not trademarked? You know what I'm saying? Or do you have to trademark both? How does that work?
So I'll give you, there's a few things in there. One is generally a last name or a name of a individual is not trademarkable. There's a few common exceptions. So if you take Michael Jordan, everybody knows who Michael Jordan is. If you've reached a level of celebrity or fame such that everybody associates a name with a given individual, you can get a trademark. 95 or 99% of us never reach that level of celebrity or that fame. So if the rest of us, you simply can't trademark a name. So if you look, so the name of my law firm is Miller IP Law, and I'm not able to trademark it because my last name is Miller. Miller is also a very common last name, and so you can't trademark use of the word Miller because a lot of other people may also want to use their last name as part of their business.
Okay.
But as far as, so there are also a couple different types of trademarks. One is called a design mark, and one's called a word mark. So if you look at, and that's kind of where you get into with the logo. So logo is going to typically be more of a design mark. It has an aesthetic nature to it, has a look and a feel. So one of the couple of examples of what design marks are let's say you take Starbucks and the mermaid, the green mermaid they always put on the cup. That's not
Yeah.
necessarily a word; it's a design. If you were to take the Nike swoosh, that's going to be a design. Those are still trademarkable. It's simply just an aesthetic nature to it. And when you do that, what it really is whatever your design aspects of your logo or the product or the thing that you're trademarking, that's what you're protecting is those design aspects. On the opposite side, you also have what's called a word mark. Word mark is kind of what it sounds like. You're protecting the use of the word. So if you think of Nike, they have a trademark on the word Nike for athletic wear and apparel and shoes and athletic gear. Apple has a trademark on the word Apple for consumer goods, for smartphones and computers and those type of things. So you can get it on the design a lot of times, and or you can get it on the word. Or if you have both, then you can get it like Nike has a word mark for the name Nike. They have a design mark for the Nike swoosh.
So then copyright and like music. So you see now you're having to say, I don't own the rights to that. And then just about everything. And it on media, if you're doing something and you're playing music. And I've also found that, let's say you have, like for right now, the background of like, I had to find that. I had to pay for that.
Mm-hmm.
And, but for our YouTube channel, I noticed that we won't get a copyright strike because we paid for it, but I still get these alerts. So do you know how that works in the background? Because a lot of people right now are just download free music, using other people's content. How do you know what's protected and not protected? I'm saying there's so much content out there. You just wait until somebody comes after you or your logo, and then, you know what I'm saying, and do a cease and assist. You know what I'm saying? Is it people think that we should be researching first or just, trial and error?
Yeah, so generally you don't want to wait till you have that cease and desist letter or somebody threatening your business because then you're already fairly far down the path and it's hard to reel it back in. So, there's a couple that, if you're to take music or, copyrights, and we'll take music as an example, there's a wide variety of different types of music out there. Some is going to be created by an artist. Everybody owns the copyrights when they create a musical work. But some people are going to allow it to put it out on a platform where it's commercial use. Everybody can use it. They're putting it out there. They either want to build a brand or reputation, or they just start doing it for fun. And so some of them, depending on the site, you have to be careful or where you're getting the content. Some of them are free or copyright free, or they're a license free type music. Whereas others, you can go and, a lot of times the songs you hear on the radio or the songs you hear in a movie or whatnot, those are all copyrighted. And you actually have to, and there's a lot of big publishing houses. You go and pay a fee, you get access to using that, and then you have a free path forward. And then there are some that they're just, the artist wants to keep ownership themselves and they don't license it out. So you kind of have to look at what the sources that you're getting the music from, where it's from. Is there a license, or do I have to pay anything for it? Or did the artist say indicate that it's copyright free?
Okay, so then I guess it's kind of still like trial and error, and hope that's not the case. So
on copyrights, you can do your research before. So if you're looking for a movie or you're looking for a video clip, you're looking for music, you could see wherever you're getting it. Don't just go and download whatever you want from the internet. It's typically not a good idea to just copy a music or music video or music from YouTube or somewhere else. Do a little bit of your homework to see what the ownership is of that. And there are a lot of good sites out there that you can go and actually that they are set up to be copyright free. On brands, you're probably the first thing a lot of people overlook or don't do, but that you'd should do, is you should go out and at least do a Google search to see if somebody else is using the same brand for the same or similar types of goods or services. And then beyond that, it'd probably be worthwhile if you're saying, hey, we're going to put a lot of time, money, and effort to build a brand, build a company around the brand. Then you probably have a patent attorney or a patent and trademark attorney go and do a trademark search to see if it looks like that somebody else is using this or create an issue. It's a lot easier to do that up front than be years into building a brand, getting that letter, and then either having to rebrand or pay for the license for it or anything else gets a lot more expensive by the time you have to do new URLs and you have to do new logos and new branding and everything else. Can be a lot more expensive than doing a little bit of the homework up front.
So then that brings me then to, because I know that you really specialize in helping small business owners or growing business owners.
Mm.
When they hire people to do their marketing and people who are saying they're doing logos and websites and all of that stuff, how do you know that they're doing their due diligence for you? You know you get what I'm saying? Hiring the right type of marketing firm, because now listening to that, a lot of us would try to do things ourselves or just find somebody on social media, on Facebook, but maybe they're not doing the research because that's affecting our brand if they get it wrong.
Yeah, or even a platform, and we've used it before too, is Fiverr, right? A lot of people like to do Fiverr for a logo design or for a little intro to a podcast or whatnot.
Yeah.
And I don't know that I would rely on them to probably do the homework for you. Some people, if you go to a big company or reputable, that's a marketing company that has, a big reputation or, those type of things, will often do the homework for you. Still, some of them don't, but a lot of them will. But if you're going on to whether it's, Facebook and finding a freelancer, or a lot of times going on to Fiverr, most of the time they don't do the homework. It's a low enough cost budget. They just do what you hired them to do. They don't do the research themselves. So it's still the onus falls on the company owner, the business owner, to do their homework themselves. And whether that's hire an attorney or if you're going to try and do DIY yourself, to do enough of your homework, because I wouldn't rely on typically the freelancer or the one-off sites to do that for you.
So can you kind of give us, our listeners, kind of a walkthrough of of how you possibly, when you get a new client or potential someone who's, for what you do for small businesses to, advise them, because obviously there's a lot that I'm listening to that I really just didn't know. I mean, there's things that I had questioned, and there was something different when I looked into getting, I thought that I could trademark my name, because what I thought was, oh, no one can use McDonald's anymore, and I'm going to hire somebody and everybody uses McDonald's. I'm going to get rich. That was what I thought. And then, of course, these words like we were just saying common things you can't trademark. So what's the walkthrough process of someone like myself or a business owner, and how you determine, how you start to see how you can help them, whether it's copyright, non-production, non-tangible item.
Sure. So, I mean, the first thing that we typically do, and as I mentioned, when we set up Miller IP Law, was really to focus on the startups and the small businesses. So, at least for what we do, we'll have a free strategy session. People can come in, take about a half an hour, give or take a few minutes, sit down and kind of talk through what they're doing, and then outline what may make sense or what a strategy may make or be for them. And that may include, hey, you have a last name that's a McDonald, you're probably not going to be able to get a trademark on it. It doesn't make sense to engage our services. And so, we may give you that advice versus we may say, hey, you're already way past, you should have done this 6 months ago. You're probably paying catch up. Or this is when you want to think about engaging it. But we'll sit down and we'll kind of go through based on what each company is doing, have that kind of question and answer session. And the reason we mainly did that was, hey, we wanted to make sure that, because going to attorney, oftentimes people are worried that it's going to cost money, or you're going to go in, spend hundreds of dollars. The attorney is going to tell you they can't help you, or it doesn't make sense, and then you're out a whole bunch of money. Right. And so that's the first thing. And then if you decide, okay, now we've defined, yes, you need a patent, yes, you need a trademark, or yes, you need a copyright, then we'll kind of walk through what that timing might look like for you, what the costs might be for you, and when you may want to get started. And then that always is lining up with, if you're with a startup or small business, you have to look and say, now, what does our budget allow, right? Meaning we can give you the advice, but you may say, hey, we only have a $500 shoestring budget for the next 6 months to try and get a prototype out. Then it may not make sense, but at least you have kind of here's your strategy, or here's your plan of or how you'd execute it, how you'd make sense. And then based on what that strategy is, when you're ready to get going, when budget's allowed, we'd sit down and walk you through the full process and get you taken care of and get going. Does that answer your question?
Yes, I did answer my question. And then I guess the next question I would ask is that I was kind of lost my train of thought is tangible items. A lot of people on Facebook are selling and saying they're creating, their own, whether it be skincare, facial, whatever it is.
Mm-hmm.
And I read this somewhere where I actually found somebody who was utilizing, I guess, some of the product in another product, but I guess maybe just kind of adding their own additive. And this was, I forget where this was, but it was somewhere I found on social media, on like just researching. And even though the product was different because they kind of changed it, but they still it's like taking Betty Crocker cake and say, you know what, she doesn't put honey in it, so I'll just add honey to the Betty Crocker mix. Does that make sense?
Mm-hmm.
And so can you explain to people, when they have a product, aside from the importance of, having that, and that would be called the patent part of it, but the contents of their product and researching the content, I would think that you would have to do all of that.
Yeah, so I'll back up and kind of answer your question. The one example I'd probably give that's even better is let's take the television, and everybody knows what television is. And if you're to take, nobody knows that, or nobody sees them anymore. But back in the day, televisions were black and white, right? They didn't have color when they originally came up with TV. They were just black and white. And then somebody sometime came along and built a color television, right? A lot of the underlying technology still worked or was founded on the black and white television, and they added to it. But when you do that, basically, the way a patent works is you can build on what somebody else has done. So as long as you're adding something unique, different, or additive to what they're doing, you can build on it. Now, taking that example, the black and white television, the person that owns the patent to the black and white television still owns all that technology. So the person that invents the color television likely can't go and produce that until they get a license or they get an agreement with the person that owns the underlying technology. But vice versa, the person that owns the black and white television also can't now go do a color television until they get permission from the person that has the color television patent. So yes, you can build something that's unique, different, additive, but you have to a lot of times you'll build on it. And so it creates some collaboration or some licensing that takes place that you allow people to do.
So then you would aside from having to get the permission, when you have a patent of a product, do you have to divulge all of the ingredients in it and as in the production?
Yeah, typically. I mean, it depends on. So if you're going to go to the ingredients, typically what you focus your patent on is the unique or the novel features of your invention. So let's say you created a bicycle, right? Bicycles have been around for whatever, but you created a new handlebar that went on the bicycle that made it much more comfortable, easier to use, and better. Well, then your patent really doesn't focus on the whole bicycle. You haven't invented a new seat. You didn't invent a new chain or new tires. You just invented the handlebars that are better. Then your patent would focus on the handlebars. But then, yes, within your handlebars, you would want to disclose all the details of what makes your handlebars unique and different and better than what's out there. And then you do provide enough detail that somebody else in the industry would be able to understand it such that then you can show that you've invented it. So that is that level of detail.
So what part of that where you could play to support business owners to have all of these, the product that they've made, whether, it be hair care or mechanical or technical. And being in business, I get a lot of, I created my own online platform, my own social platform. They have like stuff for even podcasts or even if it's in the beauty industry. There's always something that can help my industry. But see, I never really know, is it a third party system they're using and they're just saying that they're, maybe they're not saying they're an affiliate. So how do you walk someone through if they said, hey, I'm coming out with this wax line, fingertip. You know what I'm saying? And so what questions would you ask them? How would you set it up to say, okay, yeah, you're ready? What would they be looking at if they came to you and said, this is my product? Because we watch Shark Tank, but I think Shark Tank is different,
Sure. Yeah, so the two things is one is obviously an ownership to your point. If you didn't come up with it, all you're doing is sticking another name or a different or rebranding it, then you really don't have anything as far as on the patentability side because you haven't created anything new, unique, different. You're just rebranding something. So the main two standards that we'll kind of discuss through when we sit down with somebody on the patent side, the main two standards are what's called novelty and obviousness. So novelty basically means is anybody else previously invented this. So if somebody else has already invented this, then you can't go get a patent on something that's already invented. Meaning if somebody has already created it, then it's been patented, or it's already out in the public, you can't then just go patent it. The other one is called obviousness, and then there's a couple aspects of obvious. One is basically if you were to just go take two or more things out there, let's say in the industry, healthcare industry, and you were to put them together, you're really not adding anything unique or different. You're just taking two things that are well known that you could have put together, adding them together. There's nothing unique or different. Then again, it's not patentable. The other one is if you're just making a pretty obvious tweak or variation of what somebody else has already done. Again, it's not patentable. So we would go through and say, first, make sure you have ownership. And then second, say, is what you're doing novel? Is what you're doing non-obvious? And if so, then you'd have a good path forward in order to go after a patent application and vice versa. If you're not doing it, doesn't mean what you're not doing may not be valuable, may not be able to go out and make a lot of money in the marketplace and do very well for yourself. It's simply just not patentable. And so it'd say it doesn't make sense to go after a patent because what you're doing isn't novel or what you're doing is too obvious, but go ahead, go build a business around it nonetheless. And good luck to you and or wish them the best of success.
So, okay. So let's talk a bit about copyright.
Sure.
So, I mean, it's really easy, I think, for anyone to say that someone has used, their what do you call it? I guess their verbiage. I guess would be the word. So I'm in the accounting industry, and so it took me a long time to write this manual I wrote, and it took a direction for startups and small businesses because I kept having to think, oh, has that been said? Because accounting is accounting. Let's be real. Whether how you give direction to startups is different, but using the same verbiage is so common. So, what does copyright look like? I mean, because for me, I could have something and say, well, I've said that 100 times. CPAs, we say that all the time. I was like, but is that copywritten just because I've used, well, a P&L looks like this or balance sheet looks like this because somebody said it first. How do you know what copy and not technically what can be misconstrued as you copyright this? Am I making sense?
Yeah, it's a good question. It's a bit harder question, so it's certainly kind of a case by case. But as a general, if you look at copyrights, it's first of all, so everybody that creates a copyright is for whatever you create. So let's say you came up with one verbiage that describes how you could do accounting, and somebody else came up with a different verbiage. It has the same meaning, but it's said two different ways. Yeah. Then both people have different copyrights for the different ways they say them. Just like you could take, you take all the movies out there. A lot of movies have a similar plot line, but they just have a little bit of different, they have different actors or they have different, locations, but they have a lot of the same plots. But each person created a different way that they're doing it, and so they each can have copyrights towards those different words. But it's really, then the second question is if everybody's been using this verbiage, the same verbiage or similar verbiage for a very long time, then you're really not creating anything that's copyrightable, meaning what you're coming up with, everybody uses. It's industry standard terms, it's industry standard ways of explaining things. You're really not going to be able to copyright on it, or you're at least not going to be able to stop somebody else from getting a copyright. Kind of as another way maybe to explain it, give you an example. Let's say you went out and you took an awesome picture of the Eiffel Tower. It was awesome. Lighting was great. Picture was great. Everything else great. You have a copyright for that one. Let's say now I go to the Eiffel Tower and take a very similar picture that I took with my own camera. I didn't copy you. I didn't still take it from you. I went out and took my own picture, but they both look similar. we both have a copyright for our own picture because we both created it. So if you're creating something, you can have people that create similar things as long as they're not ripping it off, copying it, or taking it from someone else. There can be a lot of similar copyrights out there. Does that start to answer your question a bit?
Yeah. And I know that from what I researched when I was, and I kind of stopped because I was going to do the McDonald's, so I realized that didn't work.
Hmm.
But then I recall there being a lot of questions how you're going to use the name or use the brand. And the more it's like, okay, well, are you going to use it if you use it on social media, on business cards, I don't know, your ISP web address on the website. So when you do have something trademarked, then do you have to define all these areas or of how it's going to be used? You know what I'm saying? And make sure you're covering all bases, or is that not necessary? Is it, you know what I mean? Or you say, okay, I have a trademark, now you just can't use it no matter what it is. Not a hashtag, not an at, not in anybody's book or magazine or, on somebody's webinar. Can you, or do you have to specify each individual way it can be used?
Yeah, it's almost the flip side. So when you're applying for a trademark application or for a trademark, you have to identify what we say is the types of goods or services. So types of products or services you're going to use it for, and that's what you actually get your trademark for. So theoretically, Apple is electronics. They have trademarks when they applied for smartphones and computers and consumer electronics. They don't necessarily have a trademark for automobiles. So theoretically, although I don't know that I would, Apple's famous enough, maybe you wouldn't want to do it, but you could go and start a truck, an automotive company, and name it Apple because it's different than what their types of products or goods or services are. And people aren't going to think the same people that are making smartphones are now making cars. So take Nike as another example. People aren't going to think Nike is going to go make automobiles. So when you file for a trademark, you identify or you define what types of products or goods or services you're going to use your trademark for, and that's the scope of coverage you get. So you then have trademark for those types of goods or services. But if there's something different or out there that's not the same as your products or goods or services, you can actually have multiple companies use the same word or the same type of word or phrase for different types of companies that are significantly different.
So I noticed on your website that for us beginners, I guess, you have, and I have your website up, by the way, that you have, I guess, some questions that we would most commonly ask that would help us understand, which is, can I prepare and file my own patent or trademark? You know what? I'm going to be honest. I was going to do it, and I got really lost because it started asking questions like I just asked. And I really think that the guidance of someone understanding their business and why they're really doing it, I guess. So, and the purpose of doing it, which so in your website where you have kind of Q&A, are they able to kind of talk to you directly? It looks like you kind of a scenario of questions here.
Yeah, so the website we provide, one of the things we do on the website is we're trying to have it as a learning library, a place that people can come and get information. So generally take the kind of, can I do it myself? The short answer is yes, you are able to do it yourself. And then then what we do is talk about the merits of doing it yourself. Well, it's better to have some sort of protection, something in place rather than nothing. So if somebody to come and say, hey, I can't afford your services, am I better to just not do it at all or do it myself? And I'd probably say, well, again, something is better than nothing. If those are your only two options, I'll do it myself. And then the question is if you have some of the budget or the ability to do it, is it better to try and do a DIY it, or is attorney really add any value? Is it worth going to attorney? And then that question is a lot of times what I see is when people try and go do it themselves, to your point, they either get part of the way through the process, it's confusing, it's not straightforward, which is oftentimes the case. And or even if they do get all the way through the process, a lot of times they don't know, it gives them almost a false sense of security, right? They think that they did it all right, they did all the information, now they're protected, only to come and find out they didn't do it right, they don't have protection, or they have limited protection, or they don't have what they thought they did. So a lot of times it's more of, does it make sense to do it yourself? or can you figure, or would it be better to work with an attorney so that you can make sure if something is valuable, if your brand, your product, whatever it is valuable, then you're better to have it done right to make sure you have the protection that you're wanting.
So unfortunately my co-host can't be here, but I know that when she started, she wanted to use her, like mine is McDonald Bookkeeping Services, and her last name is Walker. So she was going to use Shamar Walker, consult, but she found out, the Walker was used already. And then she was going to do SWHR. She found out somebody already had SWHR, so she had to use SW and then I guess break the HR, something to that effect. So before she could do that, would you say it's more important to, because we've explained the name thing, to for a business professional like ourselves, is trademarking or branding your logo more important, or maybe content that you use, or would it be both?
I'll give you the simple answer. We can dive into a bit more. It depends on where you think the value of your business is, right? So let's say, why do you go and buy Starbucks, or Starbucks coffee? And I just use them as a recurring theme. It's because that they've built a very big brand. Everybody knows what types of products they offer, and so people are really going to Starbucks for their coffee or for the product that they know that they'll be getting. And so if your business is built around a brand, then you probably want to protect the brand more. If on the other hand, let's say content is really, it's not as much about the brand, but you have really good content, that's what's driving people. They're finding it very interesting. They want, and that's where all your value of your business is, then you're probably going to protect your content. A lot of times it's not quite that straightforward. A lot of times it's multiple things, right? Your content feeds into your brand. Because you have really good content, people now recognize your brand and trust your brand, or vice versa. You have a very good brand and now people are coming to you for additional information or for guidance. And so a lot of times you're going to build it or layer it on top of each other. But the short answer is I would look and say, in general, wherever the value of your company is, that's where you put the most time and effort in order to make sure it's protected. Very general. If you're in a product, or you're developing a product or a good, an invention, I typically start out is with a patent. If you're building more of a service-based company or something that doesn't have something unique from a product perspective, then you're probably going to start with a trademark to at least build your brand or protect your brand. So as you build it, have great content, do great videos, do great podcasts or whatever, that you at least have that brand protected, that you're building everything else around.
So what does it look like when, now, okay, let's just say I did it myself, and or you hired someone to do it for you, whether that be trademark, patent, whichever. And then you find that someone's using your brand or whatever it is. So would it be at the best interest of the consumer, like myself, the business owner, to always have someone on board so that they deal with the litigation part? And or is that something like that we could do ourselves? I would think not, because I wouldn't even know what to do.
Yeah, so if you were to have someone that's starting to, what you believe, to knock off your brand, the first thing I do is just a bit of homework to see if they were the one that started using it first and you're knocking off their brand, or if they're knocking off your brand, right? So sometimes you'll get, hey, I've had this brand for 5 years and I just noticed somebody started to use it. You do a little bit of homework only to find out that person has been using it for 20 years and you're really the one that ended up copying them type of a thing. And so that's the first thing you want to see is, are they the one that are at issue, or are you the one that is at issue? Assuming somebody else is copying or knocking off your brand, then I always look at it to see if you can find a solution before you go to a legal solution. In the sense that, maybe that they didn't know that they were knocking off your brand, or they're unaware of it, or they think, they didn't know that it was going to create an issue. Then you may go to them and say, either go to them and say, hey, you're knocking off our brand, we'd ask you to stop. Or maybe you want to say, hey, would you like to take a license? Maybe you pay us so much and we'll let you continue to use your brand, and then you have a source of income. Or you may say, hey, you need to stop using it. If you're not going to stop using it, then you'll send out what you see is like a cease and desist letter. If they ignore that, then you'll go to take into court and you'll have to you'll enforce your trademark against them in court. But I usually always start with the business solution first before I go to the legal solution, because a business solution will often have a more favorable outcome for everybody, doesn't cost as much, doesn't have the time, money, and effort that's involved. It can often be a better result, but sometimes you still have to go to court in order to get things resolved.
Okay, so then now when you say licensing, there is content that I had purchased for my marketing. I have someone doing my marketing, but I remember some came with license, and it's like to buy the light. Then I had to get all this instruction on how to use it and all this other stuff that came with the marketing material. Let's just say someone came to me, and they were going to sue me for something, and so I don't know if insurance comes along with that, or if you have, or is it necessary or not necessary? Because we know about our business insurance, our general liability insurance. Would something like that be covered if to find we were utilizing someone else's, material that we shouldn't have been, that was covered in a trademark, or is that something built into our insurance, or is that like something that's separate?
Not most insurances is not necessarily built in. Some insurances policies, and most of the ones I've seen, I'll put it that way, because there's a lot of insurance out there. Most of the ones I've seen are where it's not necessarily built in. So if you infringe a trademark or patent or copyright, generally your insurance isn't going to necessarily cover it. There are some insurances out there that cover that in case of liability for patents or intellectual property, patents, trademarks, or copyright infringement. Most of those are very expensive policies and don't provide very good coverage, and so there are a few good ones out there, but they're much more far and in between than the most of the ones out there. So generally, unfortunately, there's not most of the time there isn't a good way to insure yourself against that. You try and do as much homework as you can up front. Make sure, hey, before we build a brand, let's see if let's go out and see if there's somebody else using it. Let's do a little bit of homework. Same thing with patents or trademarks. And then you said beyond that, then you're going to just have to build it in as almost a business expense. If that comes about, or if that's due, you're probably going to have to figure out how to either arrive at a reasonable solution with the other party or be willing to defend yourself in court. And I said, unfortunately, there's not a good insurance issue and a good way to typically insure against it.
So it would behoove someone like myself or a small business owner to really make sure you have a good marketing firm, for one.
Mm-hmm.
And or at least consult with one, and or then when it comes to growing your business, when you start to launch, at least sit down and talk about your business and where you want to be in your future goals and what it looks like. So I mean, I would assume that you would recommend. Hearing this, I would recommend that. Obviously,
it'd either be sitting down with a good marketing firm and/or a good attorney that can walk you through and say, hey, here's what we do with the marketing company. Here's all the things that they're doing. Can we go out and do a search, or is there anything we should be aware of? Is there anything we should look at as we're rolling this out before we go and roll it out? So a good marketing firm may have that as somebody that they already use. They may do that for you, or somebody that they'll recommend to you. Or you can simply go out and find a good attorney outside of the marketing firm as a way to cover. So sometimes, depending on the situation, sometimes you won't get necessarily an honest or straight answer from a marketing firm because they're self-interested, right? And I'm not blaming them by any means. They're doing a very good job in making a good brand and making a good logo, getting a marketing plan, but they don't necessarily have the legal experience, just like an attorney doesn't have a lot of the marketing experience to give you a lot of marketing advice. And so a lot of times you're better to simply separate those two a bit so that you get the expert advice from the different people that are doing the different aspects.
That's a lot. So is that something that you can connect consumers with, or small business, because you're able to relate to the two, or you work with firms to say, okay, I can direct you in that area before we start launching your product?
Yeah, a lot of it we could either sit down on certainly from the legal perspective, give you advice, work with you, and go through it. I do know a few marketing firms that I know of or recommend or that we could do it. They're not going to necessarily do the homework on the legal side, but could help you on the marketing side. But on the legal side, to make sure you're protected, yeah, that's something a good attorney would be able to sit down and help you out with.
Okay, so I'm back to your website, and where it has all about trademarks. And so you have here some common mistakes business owners make. I thought we could like kind of walk through that, if that's okay with you.
Sure. And it's been long enough. I'd have to look at which common. There's enough common mistakes. I probably grabbed a few. But one of the ones that you can see that pop up there first is the ones that say, if I start using the trademark first, there's always the assumption that, hey, then I'm fine, right? If nobody else is using it and I start to use it, the problem is when. So if you don't register a trademark with the federal government, with the Patent and Trademark Office, then what you have to rely on is what's called common law rights, or sometimes called state rights. And that gives you, it does give you some protection, but it only gives you the protection for where you're using the mark as of the time that somebody else registers the mark. So let's give you an example. Let's say today you started using, even though we said you can't do your last name, McDonald Bookkeeping and Services, you started using that today, and you were only selling in New York City, New York. And for the last 5 years, you've only been selling in New York City, New York. Somebody else could come along afterwards or after you, register that trademark for the same company. They would have the rights to use it everywhere except in New York City, New York. Meaning you could keep using it in that area. You can't expand out. You can't go anywhere else. So you can keep using it, but you can't ever grow your business. And so that's one of the kind of the common misconceptions. People think, hey, if I'm the first one to use it, I'm fine. I'll go buy the URL, I'll register it with the state, and then nobody else can use it, which isn't the case.
Okay. I'm sorry. Yeah. I thought that. I literally thought that. Okay. And before I get to this next question, okay, so I have heard that if you send something to yourself, you certify, register, mail it. That means it's all yours. Have you heard that before?
I've heard it frequently, and it's bogus or it's wrong. So, where the genesis or where that came from is it used to be, although the U.S. isn't, it used to be under just patents that it was under a first to invent system, meaning the first person to invent it, as long as you can prove you invented it, then you would have the rights to it. Back in about 2013, the U.S. changed to conform to about the same system as the rest of the world used. It's now a first to file system, meaning whoever files on it first is presumed to be the inventor of it. So mailing it to yourself is great, and if it makes you feel good, by all means, it doesn't do you any good for protecting it or to give you any sort of coverage. And so while it's a myth, I know that it floats around on the internet, and I get that question asked, on a routine basis. It doesn't do you any good. It doesn't give you any coverage.
Okay. Okay, so the next thing we have is trying to trademark or copywriting a creative work. And is that what you're talking about, the art?
Yeah, so sometimes people get confused. Hey, if I come up with something that's creative, I want to go and try and get a trademark for it, which you really can't. So you can't go trademark a movie. You can trademark maybe the name of the movie, but you can't go trademark the whole movie. Same thing with a book. They think, oh, I wrote a book. Now I need to trademark my book. Again, you might be able to trademark the title, but you're not going to be able to trademark the whole book. So sometimes people look at it and say, they think that they need a trademark when they need a copyright, or they think they need a trademark when they need a patent, or vice versa. And so I think that's kind of what 1 or 2 and 3 go towards, is you want to figure out what you actually need to protect, and then you need to make sure you get the right protection.
Okay. This would be for
go ahead.
Okay, so confusing trade with business registration.
Yeah, so that kind of hits on what we talked about. A lot of times, there's two things that people oftentimes kind of get confused about. Is, hey, if I register my trade or register my business with the state, and or if I go buy the URL, so I go to GoDaddy and I go buy the URL for my business, then nobody else can use it, right? Or another thing, the way they think about it is sometimes if the state, or if I register with the state and the state doesn't reject it, or if I buy the URL, I must be cleared, meaning nobody can come get mad at me. Both of those would be wrong. So registering with the state, they don't do any sort of trademark search. They don't look at it from a trademark perspective. And why you may register with the state doesn't mean that you're not infringing somebody else's trademark. Same thing with the URL. Somebody may just have bought a different URL, but they still have the trademark for the name of their business or the name of their product. They just didn't buy the same URL as the name of it. So you're not able to just, by buying the URL or registering with the state, get a trademark coverage. It simply allows you to have a URL to direct your clients to and have a registered state so you can pay your taxes, but it doesn't give you any trademark coverage.
Can you trademark a hashtag?
Sometimes. That's a longer question. The short answer is yes, you can do hashtags. It can be trademarked, but it has to be one that's unique or identifying with the product or good or service of your business, and it has to be something that's not one that's already commonly used out in the marketplace. So yes, but it's difficult.
All right. Okay, well, this is a lot today, and I hope our listeners have gained a lot out of this because I definitely did. So I was hoping that you can tell people before we close out the show is just kind of, how they can find you, which obviously you're here, but, just some insight that you can give them on how you would direct them when consulting with them.
Yeah, so easiest way to find us, I'll give you kind of a few different ways to connect. One is you can see that we have the website. That's a good place if you just want to find out some general information or want to find out our pricing structure or those type of things. They can just go to milleripl.com. So I is in intellectual, P is in property, L is in law, milleripl.com. And they can find a lot of good information about us. If they're wanting to, you can also schedule a free strategy session on our website so we can grab some time with them. They can get have that scheduled, and that's free of charge. The other way, if they want to go directly to the same place, you can just go to freestrategymeeting.com. You can also grab some time and schedule it for a free strategy meeting. And then the last place that they can find is if they just want to reach out to me, they have any questions, whether it's get to know me, ask questions about business or anything in between, you can just go to meetdevon.com. So meet MEET or MEET DEVIN, meetdevon.com, and they can grab some time on my calendar, my schedule, and they can meet. So those are the easiest ways. And then certainly on LinkedIn, I'm pretty active on LinkedIn. So if they were to go in and look me up on LinkedIn, I'm happy to connect there as well.
So one last thing before you go, though. I'm sure we can get a lot of insight just off your podcast as well. And maybe, is it open to ask questions on your podcast?
So yes and no. So people, if they wanted to submit it ahead of time, we do. So we have two parts of our podcast. One is what's called the inventive journey, where we have guests on. They come on and just tell how they got to where they're at today. So we take a lot of businesses that are saying, "Hey, we're now starting this business or growing this. Let's talk about that whole journey." Because the problem with most startups and small businesses is you only get you watch the movie, you read the book, you get to hear the highlight reel. You only get to hear all the things that we were an overnight success and everything went perfect, and that's never the case. And so this is a real world. Hey, this is how real people are building their businesses. This is a journey they took. So that one's that one. That one's not as open to questions, but we also have what's called once a week. We also do an expert episode where we have different experts come on. So we've had and/or will have aired some of them, like for instance, a marriage counselor that's come on and talked about how to keep a good, strong marriage while doing a startup. We had a angel investor come on and talk about how to get angel investor dollars. Or we had another one was an incubator. So a lot of incubators out there to help you develop your ideas. So on those ones, yeah, that one, if they wanted to, they can just reach out to us. They can email us or submit a question on the comment section, and we'll incorporate that into that section. So that's a place they can do it. If they wanted to have it addressed in the podcast, and if they wanted to reach out to us specifically, then they can just go to get us book a free strategy meeting.
Well, I want to say thank you for being on our show, and to our listeners, thanks for even though we're a bit late today because of technical difficulties, that you're still back because I see you on the little I see the feed here, so I appreciate it, and for having our first actual attorney that I think is so useful and so tangible to any small businesses. I mean, seriously, even if you think you're not ready, or maybe you don't know if you need to have something trademarked or patent, it's just so good to be able to sit down and consult to see who you are or where you might be. So I would definitely say to get a hold of you for sure. So we're going to close out the show this Saturday. And we are here every Saturday. I'm Rose from Entrepreneur Life, your host. I'm here with Devon Miller of IP Law. You will be able to check out the interview on our show page, entrepreneurlife.show, on our YouTube, or just listen on your favorite podcast. Download all the time. And if you have missed something, just check it out and you can find out how to get a hold of him. He will be all over our social media. So for everybody who has been subscribing and listening, thank you, as our followers have grown. We hopefully will be at 1 million in a month. Keep your fingers crossed, everybody. And we will see you guys again next Saturday. Bye, everybody. Thanks for listening.
See you later. Thanks for having me on.
Bye.